Welcome to ECR Tours. We continue with the ICCPR, which is the International Covenant on Civil and Political Rights, which was signed in 1966, December 16, 1966, and came into force on the 23rd of March, 1976, 10 years after. This is to do with the ratification of these international treaties. As mentioned earlier in the previous volume, the first volume, I did talk about the various schools of thought of human rights, which was expressed in Professor M.B. Dambo's article, which asks you about what human rights is, and basically gives out these four schools of thought. One being the naturalist, that believes that human rights are just inherent, just as you are born as a human being, you do have, being a member of the human family, that you do have those rights. And then he talks about the deliberative school, which actually says these rights are there, but they have to be written down and basically signed and ratified, so that when they are being abused, that you can directly refer to it. In effect, that is what brings us to the ICCPR, which is a legally binding international treaty on all its member states, which currently stands at 173. In addition to the ICCPR, is also the ICESR, which is the International Covenant on Economic, Social, and Cultural Rights, which was also signed in 1966. That we will deal with that aspect in the subsequent volumes. Now, all these are born out of the Universal Declaration of Human Rights, which was also signed on 16th of December 1948, and obviously that is just a declaration, so it is not a legally binding international treaty. However, it has been widely accepted on the globe, and it is also morally, it has that strong moral background. It has also made its way into the general principles of law, that is countries are basically adopting the contents into their own laws. It's also making its way into customary international law, so it's sort of very well accepted. However, the ICCPR and the ICESR is what is actually legally binding. And so the next school of thought by M.B. Dambo is the protest group, that also believes that human rights, you have to protest for it. Just like the case of George Floyd, when rights are being abused, and even apartheid South Africa, and even the current situation that we have in the Middle East, where you see demonstrations going on just to fight for the rights of the people whose rights are being abused. And then you have the last school of thought, which is the what's the last school again? So you have the deliberative. I need to check this out. One moment. Yes, so this is the discourse school, that basically advocate that human rights, they just need to be talked about. So the more we talk about it, the more that it gets accepted. But in my opinion, and this is my own opinion, that all the four schools of thought does come together to make the entire human rights and fundamental freedoms work better. But I am more interested in the more active approach, which is the deliberative school, which is where things are written down and can be referred to. And also, when those rights are being abused, the protest group can actually, basically demonstrate on such abuses to actually drive change. Then obviously you have the passive approach, which says you have those rights. But as I said earlier in volume 1, is that you have these rights, but they are being abused. So you've got the genocide in Rwanda in 1994. You've got apartheid South Africa. You've got the Mau massacre in Kenya. Even King Leopold II murdering 16 million Africans in the Congo. Slave trade, the Holocaust. So the list is endless. And so this is why it is necessary that, you know, these international treaties, you get the nations to sign them and ratify them, so that when there is a breach, you can actually try them in an international court, basically the International Court of Justice or the International Criminal Court, and, you know, bring these probably officials or state representatives into to judgment, basically. Anyway, without further ado, I'm just going to go further on and basically carry on from Article 5 of the ICCPR. Remember to basically like our videos, share it, add your comments and contributions. As I always say, it is a learning curve. Basically, we are all here to learn, and also to share, so that everyone knows what their real rights are, you know, under international law, and such that if such rights are being abused, then you know what to refer to, obviously, to defend your rights. So Article 5 of the ICCPR says, nothing in the present covenant may be interpreted as implying for any state, group or persons any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. So basically it's saying that these rights that are enshrined in this ICCPR must be protected. Under no circumstances must anybody do anything to basically come into contravention with these rights. Article 5.2 says, there shall be no restriction upon or derogation from any of the fundamental human rights recognized or existing in any state party to the present covenant pursuant to law, conventions, regulations, or customs, on the pretext that the present covenant does not recognize such rights, or that it recognizes them to a lesser extent. Now, what this is actually saying is that the articles held here within the ICCPR must be upheld, and basically must be the one that should basically supersede. That is, if any, assuming that any domestic law comes into contravention with the ICCPR, then those laws, the ICCPR must supersede those domestic laws. So we move into part 3 of the ICCPR, which is Article 6. And so, as I mentioned, this ICCPR, which is an international treaty and is legally binding upon the nations that have signed for it. You have 173 nations, which includes the United Kingdom. It includes Israel, Ghana, Nigeria, countries in the Far East, even including China. Russia is also a signatory to this ICCPR. So Article 6, which is in part 3 of the ICCPR, Article 6.1 says, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. And so this is the right to life, Article 6.1. Very important to the individual. You have that right to life, and no one shall be deprived of that right. Okay. So Article 6.2 says, in the country which have not abolish the death penalty. Sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime, and not contrary to the provision of the present covenant to the Convention on the Prevention and Punishment of the Crime of Genocide. This penalty can only be carried out pursuant to a final judgment rendered by a competent court. And so there you have it, that if there should be anything, anybody committing any such crimes, then they should be brought to a competent court. And also that the death penalty should be basically the last punitive result. For this is applicable to nations that have not signed up or basically impose abolition of the death penalty. As we know now, the European Convention on Human Rights, in its further protocols, have actually abolished the death penalty. And so this is a very interesting situation where, as the Europeans take that lead, then it kind of creates that spillover effect for other countries to basically get involved and say, okay, we are also abolishing the death penalty. And so this is how international law really works. So you see that from the American Declaration of Independence in 1776, and also the U.S. Bill of Rights. Then you've got the French Declaration on the Rights of Man, 1789, and then then follows on, and then it comes all the way down to the formation of the United Nations in 1945, which then leads on to the UN Charter, Universal Declaration, and they all sort of building upon each other. And so this is how these international laws are actually made. Now, we go to Article 6.3, which says, when deprivation of right constitutes the crime of genocide, it is understood that nothing in this article shall authorize any state party to the present covenant to derogate in any way from any obligation assumed under the provision of the Convention on the Prevention and Punishment of the Crime of Genocide. And so if genocide is committed, then it needs to face its own punitive judgment, basically. Article 6.4 says, anyone sentenced to death shall have the right to seek pardon or commutation of the sentence. Amnesty, pardon, or commutation of the sentence of death may be granted in all cases. And so if an individual is basically sentenced to death, then in Article 6.4 it says that they do have the right to plead for pardon, and obviously such rights may be granted. So that's fine. Then we come to Article 6.5. Sentence of death shall not be imposed for crimes committed by persons below 18 years of age and shall not be carried out on pregnant women. And so there you go. Article 6.5 is actually stating that anybody under the age of 18 may or shall not be basically subjected to the death penalty, and also pregnant women. Article 6.6 says, nothing in this article shall be invoked to delay or prevent the abolition of capital punishment by any state party to the present covenant. And so once again, it does encourage the idea for the abolition of death penalty by all nations. It does not want to see what's going on. Okay, great. Okay, so we go to Article 8. So Article 8.1 says, no one shall be held in slavery. Slavery and the slave trade in all their forms shall be prohibited. Now, this is a very interesting one. Article 8, talking about slavery that is being basically under some sort of servitude or being forced to work in a way that you feel that you're not basically being rewarded in the way that you're probably serving, or maybe forced to serve. So that is prohibited under Article 8.1. But in modern times, we see this modern day slavery where people are basically working and basically struggling to meet their basic subsistence living. Now, all this is also under the ICCPR, which is the International Covenant for Economic, Social and Cultural Rights. It is the duty of the state to ensure an adequate standard of living for all its inhabitants. And so it puts the onus on states to ensure that they have policies in place to protect labor rights, to ensure that when people are working in normal jobs, that they have a decent living standards, i.e. on basis of accommodation, their education, their health, and their cultural activities, that there should be a decent and a balanced way of living. And so all this is the states are responsible under international law to provide for their inhabitants. So Article 8.2, no one shall be held in servitude. So once again, modern day slavery, where people are captured from one country to the other and placed under some sort of prostitution or forced labor and all that stuff, is all prohibited under Article 8.2 of the ICCPR. And so this is when you see that when any of these type of things are spotted within a country, I have probably, within the UK, we have seen that happening, where the police goes in and do their best to arrest all the parties that are involved in bringing people under servitude or any form of slavery. Article 8.3, Section A says, no one shall be required to perform forced or compulsory labor. Obviously, with the exception of the fact that maybe they have been tried under a court of law, and a judgment has been passed upon them to carry out a certain labor, say community service or something. Other than that, no one shall force any other person for compulsory labor. That is prohibited under international and I'm sure under domestic laws as well. So Article 3B, Article 3B, paragraph 3A, no one shall be held to preclude in countries where imprisonment with hard labor may be imposed as a punishment for a crime, the performance of hard labor in pursuant of a sentence to such punishment by a competent court. Article 3C. Article 8.3c says, for the purpose of this paragraph, the term force or compulsory labor shall not include 1. Any work or service not referred to in paragraph B, normally required of a person who is under detention in consequence of a lawful order of a court, or of a person during conditional release from such detention. So this one obviously goes on to confirm that, under a court order, if there is a punitive judgment placed on a person, then that person may then have to serve that labor, whatever labor instructions they are under, they must serve it according to law. Any service of a military character, and in countries where consensus objection is recognized, any national service required by law of consensus objectors. This is to do with national service, that if in a nation there is that requirement for everyone to do national service, then so shall it be. Any service exacted in cases of emergency or calamity threatening the life or well-being of a community. So once again, if you live in a community and let's say there is a situation which is endangering the life of the community, then the community members may then be asked or may be forced to work for the protection of that community. But that one can only say that these things only happen under emergency circumstances. So Article 8(3), paragraph 4 says any work or service which forms part of normal civil obligation. So once again, that is in confirmation of what has just been said. So the next article is Article 9. So ICCPR Article 9 says, Article 9(1) says, everyone has the right to liberty and security of person. No one shall be subject to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds and in accordance with such procedure as are established by law. So this is Article 9(1) is to do with arbitrary detention that is also prohibited under ICCPR. And so we may probably see issues in the Middle East that may be violating Article 9(1). And so, that is also an issue. So Article 9(2), anyone who is arrested shall be informed at the time of arrest of the reasons for his arrest and shall be promptly informed of any charges against them. So you also notice that domestically, when an individual is arrested by the police, they do read out their rights to the person, why they are being arrested, what charges are being brought against them. And so this, when the police are doing that, they are doing it because under international law, ICCPR, they are required to do so. Otherwise, that may constitute arbitrary detention. If the person is arrested and they are not being explained the reasons why they have been arrested, and they don't actually know what charges are being brought against them, then if a government official or anybody in an official capacity or a state official capacity arrest an individual without performing these requirements, then this may be deemed arbitrary arrest and shall be in contravention with Article 9, Article 9(2). So Article 9(3) says anyone arrested or detained on a criminal charge shall be brought promptly before a judge or other officer authorized by law to exercise judiciary power and shall be entitled to trial within a reasonable time or release. It shall not be the general rule that persons waiting trial shall be detained in custody, but release may be subject to guarantee to appear for trial at any other stage of the judiciary proceeding and should occasions arise for the execution of the judgment. So this one, once again, we see that domestically, that if a person is arrested, then they should be brought before a judge within reasonable time, where they get tried, by the judge. And obviously, between the time when they are arrested and when they are brought before a judge, if the time is relatively longer, then those persons must be released. And obviously this is where you talk about a bail, where they get released, but then there is a bail on them, because in a way of protecting that whilst they are being released, that they don't maybe escape or run away from the country. The bail is then placed on them. And so, but under serious crimes, there are exceptions. Under serious crimes like murder and stuff like that, these persons may be held in custody longer than the required period. Sometimes these are done for the safety of these persons, but under normal circumstances, such things should not happen. So Article 9.4, anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court, in order that the court may decide without delay on the lawfulness of his detention and order his release if the detention is not lawful. So I take that again. Anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court, in order that the court may decide without delay on the lawfulness of his detention and order his release if the detention is not lawful. So this is where if a person gets detained or arrested and placed in detention, then that person does have the right to actually bring a court proceedings against whoever is detaining them, so that the court will then decide if this detention is lawful. And if it's not lawful, then the person gets released. Then we go to Article 9.5, says anyone who has been the victim of unlawful arrest or detention shall have an enforcement right to compensation. So once again, very important, Article 9.5, that if it is known that a person has been unlawfully arrested or detained, then there should be an enforceable compensation right for that particular person. Okay, so Article 10 of the ICCPR, Article 10.1 says, all persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human persons. So obviously, if a person is deprived of their liberty, so that's obviously even persons that are under detention must be treated with humanity and with respect. And so if a person is detained and their rights are abused, then surely the person have recourse to the state official or the person in power that have arrested them, have that responsibility to ensure that they are well protected under such detention. So Article 10.2 says, 10.2a, accused persons shall, save in exceptional circumstances, be segregated from convicted persons and shall be subject to separate treatment before appropriate to their status as unconvicted persons. And so this is very important, i.e. so Article 10.2a is talking about an accused person and a convicted person. So these persons must not be put together. They should be separated on the basis of the fact that a convicted person, they have been charged with the crime, tried under the court of law, and have been convicted of a crime. So they are prisoners, if that should be the case. But an accused person have not gone through that process, a complete process. They've just been accused, and so they may be under the detention based on the accusation, which may or may not be founded, and therefore such persons must be separated from persons that are actually convicted. So that is Article 10.2a. Article 10.2b says that accused juvenile persons shall be separated from adults and brought as speedily as possible to adjudication. So once again, if a person is under the age of 18 and obviously they are being accused of any crime, then the law, obviously according to Article 10.2b, that they should be swiftly brought before a court and tried, and also they should be separated from adults, right? There is a case in Australia where I think maybe younger persons may have been put in the same place as adults, and so there was a bit of an issue. Probably in my next video, I will research on that and sort of try to highlight that case in Australia where juveniles may have been placed in same circumstances as adults, and whatever the reasons were. So Article 10.3 says the penitentiary system shall comprise treatment of prisoners, the essential aim of which shall be their reformation and social rehabilitation. Juvenile offenders shall be segregated from adults and be accorded treatment appropriate to their age and legal status. And so this talks about, the idea of that people that are placed in prison, the concept is basically to work with them, to reform them, and to rehabilitate them back into society. But it then talks about juveniles who must always be segregated from adults and be given a kind of a treatment that is appropriate to their age and legal status. Article 11 of ICCPR says no one shall be in prison merely on the grounds of inability to fulfill a contractual obligation. So that is very clear. So in the event that you enter into a contract with somebody and for one reason or the other you are not able to meet the obligations of that contract, then you should not be in prison for that. So Article 11 of the ICCPR, you must also note that that is an important law. So then we go international treaty. So Article 12, everyone lawfully within, Article 12.1 says, everyone lawfully within the territory of a state shall, within that territory, have the right to liberty of movement and freedom to choose his residence. So there you go. If you live in a country, you're a citizen of that country, you have or the right to live in that country, then you have the right to choose any location within that country that you